It is Sunday, February 8th, and we are witnessing a collapse of legal norms that has no parallel in modern American history. That a federal judge has officially ordered United States Marshals to move on Ivanka Trump. So we are talking about a manhunt for a former senior White House advisor. The stakes are $47.3 million, 127 specific documents, and a prison sentence that is now firmly on the table. This situation has escalated with a velocity that has caught almost everyone off guard. Thursday, the court filing dropped. Friday, the marshals were dispatched. Saturday, the Trump family went completely silent. And 3 days. That is the entire window it took for a financial dispute to turn into a fugitive recovery operation. According to court documents filed in the Southern District of New York, Ivanka Trump has failed to comply with a court-ordered surrender deadline. That is the headline, but the story underneath the headline is where the true damage lies. There is a detail in these filings that almost nobody saw coming, a betrayal that is arguably more damaging than the legal charges themselves. Melania Trump, the former First Lady, was subpoenaed. She was asked by legal counsel to provide character testimony, standard procedure that could have potentially reduced Ivanka's sentence or softened the judicial blow. Instead, she refused. And she didn't just refuse privately, she refused publicly, on the record, in a deposition that is now part of the federal docket. To understand the magnitude of this, we have to look at the context. Ivanka Trump isn't just a celebrity. She is a former federal official. She was convicted of financial fraud and obstruction of justice stemming from foreign business dealings conducted during her father's administration. The short version of the timeline is this. Months ago, federal investigators subpoenaed financial records tied to a massive real estate deal in Dubai worth approximately $340 million. Weeks later, a grand jury indicted her on 7 counts. Last month, a jury found her guilty on 5 of those counts. The sentencing was handed down, 36 months in federal prison. The judge ordered self-surrender, which is a courtesy often extended to white-collar defendants. The expectation was that she would show up, process the paperwork, and begin her sentence. She didn't show. That is the setup for everything we are seeing today. Critics will point out that the judge was appointed during the Obama administration, implying political bias. But the bench warrant issued on Thursday and the escalation to U.S. Marshals are procedural responses to a defendant who is simply missing. But let's go back to the Melania component because it makes this situation incredibly messy and personal. Melania Trump was brought in as a character witness. In sentencing appeals, family members are the first line of defense. They are supposed to humanize the defendant. Melania showed up to the deposition. She read a prepared statement. But when the prosecutor pivoted and asked her directly on the record if she would vouch for Ivanka's character, her response was chilling. She stated, "I am not in a position to provide that testimony." That is not an interpretation of her words. That is the verbatim transcript. We need to dive into the documents because the evidence laid out in these filings is overwhelming. The first critical document was filed on Thursday, February 5th. On page 23, it states clearly, defendant Ivanka Marie Trump failed to present herself at FCI Danbury as ordered by this court, constituting willful noncompliance with lawful judicial mandate. That is the legal terminology for running. It means she didn't show up to prison. That is contempt of court. But if you turn to page 47 of that same filing, you find the financial smoking gun. The filing references wire transfers totaling $18.2 million. These weren't standard bank transfers. They were routed through a Wyoming LLC that was registered exactly 3 days before the original indictment was handed down. 3 days. When you put those two facts together, the picture becomes clear. This wasn't a panic move. This wasn't a random decision. Someone saw this coming. Someone prepared the infrastructure to move liquid assets out of the reach of the court before the charges even dropped. I have gone through these filings 4 times, and the pattern is undeniable. The LLC was formed in January 2025. The $18.2 million was transferred within 72 hours of formation. The account was flagged by FinCEN, the Financial Crimes Enforcement Network, but it was never frozen. That failure to freeze the assets is a massive procedural oversight that is now haunting the prosecution. And then there is Exhibit F. This is buried deep in the appendix on page 89, and it is the detail that mainstream coverage is largely missing. Communication logs show 31 text messages sent between Ivanka Trump and a number traced to her former Secret Service detail. Remember, she lost her official protection last year, so this is a back channel to someone she used to work with. These texts were sent the night before the surrender deadline, and then they were deleted. Prosecutors managed to recover them. One message, time-stamped at 11:47 p.m. on Wednesday, simply reads, "Package ready, route confirmed." Prosecutors are arguing in court that this indicates indicates flight preparation, that package refers to her or assets, and route refers to an escape vector. The defense is trying to argue this refers to moving personal belongings to storage before prison. You can look at the evidence and decide which narrative fits the timeline better. Now let's look at the second document, the Melania deposition filed on Friday. It is 67 pages long. Most of it is procedural legalese, but page 34, lines 4 through 11, contain a distinct exchange that devastated the defense. The question posed was, Mrs. Trump, in your experience with the defendant, would you characterize her as someone who respects the rule of law? Melania's answer was, I would characterize her as someone who protects her interests. The prosecutor followed up asking if that was a yes or no answer. Melania replied, that is my answer. That is cold. It is well documented that the relationship between Melania and Ivanka has been strained for years. Books have been written about it. But this is different. This isn't a leaked story to a tabloid. This is testimony in a federal proceeding under oath. There is no taking it back. And it gets worse. On page 51, the prosecutor asks about a specific dinner that took place in 2024. Melania confirms she was present. According to the transcript, at that dinner, Ivanka allegedly discussed contingency options if the legal proceedings went badly. When asked what she understood those contingency options to mean, Melania responded, I understood it to mean what it sounded like. The fallout from this testimony was immediate. The judge cited this specific exchange in Thursday's escalation order. On page 12 of his order, he wrote, the defendant's own family members have provided testimony suggesting pre-planned non-compliance. Because of this, the marshals were authorized to use necessary means to locate her. Her $500,000 bond was forfeited. Additional charges for flight risk are now under consideration. All of this happened within 48 hours of Melania sitting in that chair. The third document involved is Donald Trump's statement. It was released Saturday morning via Truth Social and then formally through counsel. It is 8 paragraphs long. To summarize, he calls the judge corrupt. He calls the U.S. Marshals Biden's Gestapo. He claims Melania's testimony was taken out of context by sick people. But pay attention to what is missing from the statement. He does not deny the existence of the Wyoming LLC. He does not deny the wire transfers. He does not explain the deleted text messages. And critically, he does not say where Ivanka is. Now, we have to be fair and look at the counter arguments because the other side has valid points. Trump supporters are calling this selective prosecution and political theater designed to impact the midterms. Some of that argument holds water. Point 1, the judge, Bernard Hayes, is on public record donating $20,700 to Democratic campaigns in 2018 and 2020. That is a fact. Point 2, the case was brought by the Southern District of New York, an office that has pursued the Trump family repeatedly, creating the appearance of a pattern. Point 3, other political figures have faced similar financial allegations and received deferred prosecution agreements or fines. Why is Ivanka facing prison time? Former Deputy Attorney General Rod Rosenstein, who served under Trump, gave an interview last week where he stated that the intensity of this pursuit raises legitimate questions about proportionality. Even Alan Dershowitz, who is no Trump partisan but is a staunch civil libertarian, admitted that the evidentiary threshold for the obstruction count was unusually low. So the argument that this is aggressive is valid. However, we are looking at two truths simultaneously. From one angle, Ivanka Trump committed federal crimes, was convicted by a jury of her peers, and is now evading a lawful sentence. That makes her a fugitive worthy of pursuit. From another angle, she is a high-profile political target being prosecuted by an office with a history of targeting her family, and the imagery of federal marshals hunting her down feels excessive to her supporters. Both things can be true at the same time, but the Melania piece is the variable that disrupts the political persecution narrative. If this were simply a witch hunt, why wouldn't Melania just play the game? Why wouldn't she take 5 minutes to vouch for her stepdaughter and go home? She didn't. She went under oath and gave answers that the prosecution immediately weaponized. That isn't political theater, that is a family fracturing under pressure. Some loyalists argue Melania was trapped or pressured, but the transcript shows she had multiple opportunities to soften her language. She chose not to. When asked to describe her relationship with Ivanka, she called it professional, not close, not familial, but professional. That speaks volumes. To understand how we got here, we need the backstory. Years ago, the Trump family business model attracted IRS attention, but nothing ever stuck. Then investigators shifted their focus to foreign deals, specifically projects in Dubai, Saudi Arabia, and Indonesia involving government permits. Ivanka's role eventually came into focus. She was the point person on several of these deals while simultaneously serving as a White House advisor. The conflict of interest was glaring. Michael Cohen, the former fixer, testified that the deals never stopped. The White House simply became the sales office. Prosecutors finally built a case they could prove by establishing a pattern. Foreign permits were approved shortly after meetings with Trump officials, and profits were deposited into Trump Organization accounts within weeks. Ivanka's signature was on contracts dated during her government service. For years, the defense was that she was just a family member, not a decision maker. Plausible deniability. The Dubai deal broke that defense. Emails surfaced showing Ivanka directly negotiating terms with Emirate officials while her father was president. One specific email from 2019 reads, "Dad is aware and supportive." Let's close this. That email became Exhibit A. It destroyed the "I was just a specialized advisor" defense. Until Thursday, she had never faced real consequences. The conviction changed that. The 36-month sentence was viewed as lenient by prosecutors, but harsh by her defenders. But it was a real sentence. And when she didn't show up, the dynamic shifted from legal defense to fugitive recovery. Let's look closely at Thursday, February 5th. At 4:23 p.m. Eastern, Judge Hayes convened an emergency session. There was no public notice. The courtroom was sealed. Prosecutors presented the evidence. Ivanka was not at FCI Danbury. They presented the text. They presented Melania's deposition. The court found probable cause to believe the defendant is actively evading lawful custody. The order was signed at 5:47 p.m. U.S. Marshals were activated within the hour. Ivanka's attorneys requested an immediate stay, which was denied. What followed was a massive mobilization. Marshals were deployed to known Trump properties. Private aviation records were subpoenaed. Border agencies were notified. This all happened within a 4-hour window. But here is what everyone missed while focusing on the Marshals. Jared Kushner, Ivanka's husband, was spotted Friday morning at Teterboro Airport boarding a private jet alone. The flight plan was filed to Nassau, Bahamas. The tail number was checked and the passenger manifest showed only Kushner. However, the Bahamas has no extradition treaty with the United States for this specific category of financial offense. That is a crucial detail. Then on Saturday morning, a second plane departed from the same airport. This one had a different registration and was owned by a Montana LLC with no public officers listed. The destination was unknown and the flight plan was sealed. The Secret Service refused to comment on Ivanka's whereabouts. Her attorneys issued a vague statement saying she remains committed to resolving the matter through proper legal channels, but they conspicuously did not say where she is. Judge Hayes responded by scheduling a hearing for Tuesday and adding a new item to the docket, an inquiry into potential aiding and abetting of a fugitive. This implies the court believes she had help. The flight wasn't reactive, it was calculated. Friday, Jared leaves. Saturday, a second plane leaves. Saturday evening, the judge adds the aiding charge. The sequencing suggests a plan. Legal experts are weighing in, and the consensus is grim. A former federal prosecutor with 18 years of experience in the SDNY stated that flight from a federal sentence isn't just contempt. It is a new felony that compounds legal exposure exponentially. Every day she is missing, the situation gets worse. A constitutional law professor noted that the Marshals have broad authority here. This isn't a polite request anymore. It is the active pursuit of a federal fugitive. Even Jonathan Turley, who frequently defends the Trump family in the media, admitted that the failure to appear was a catastrophic strategic error. When both sides of the legal commentary spectrum agree that running was a mistake, you know the situation is dire. A criminal defense attorney noted that Melania's testimony is devastating, not because of what she said, but because of what she didn't say. Character witnesses who hedge their answers effectively become prosecution witnesses. Former Attorney General Bill Barr addressed this on Fox News, stating that regardless of whether the prosecution was politically motivated, the conviction is real and the sentence is valid. Fleeing was the worst possible choice. Even her defenders cannot defend the flight. The consensus is that while the conviction might have been appealable and the sentence reducible, running makes those outcomes nearly impossible. The market is reacting to this instability. Trump Media and Technology Group, TMTG, the parent company of Truth Social, dropped 14% on Friday. Uncertainty around a former president's family becoming federal fugitives creates market volatility, and investors are moving positions to less volatile sectors. This sets a dangerous precedent. The last time Marshals were ordered to pursue a member of a presidential family was never. This is entirely new territory. The rules regarding wealthy defendants and voluntary surrender have just changed. Before this, judges assumed compliance. Now, prosecutors in at least 4 districts have reportedly filed motions to modify surrender terms for high net worth defendants, citing flight risk. If Ivanka runs, every other wealthy defendant pays the price in stricter bond conditions. There is an uncomfortable truth here that nobody wants to say out loud. The justice system has never been equal. But if a billionaire's daughter with Secret Service connections can simply disappear while a regular person would be in cuffs within hours, that gap becomes undeniably visible. This is a test of the system. system. Midterms are 9 months away. Republican candidates will have to answer questions about this. Democrats will use the imagery of marshals at Trump properties. This becomes a dominant conversation for weeks. For those watching closely, the smart move is to ignore social media rumors and watch the court docket and flight tracking data. The Trump family's response has arguably made things worse. Donald Trump's 9 posts on Truth Social focused on attacking the judge and claiming Melania's words were twisted, but he offered no factual defense regarding her location. Melania's spokesperson issued a forward statement. Mrs. Trump has no comment. Republican congressional leaders have been mostly silent, with only a few defending Ivanka by name. Eric Trump called into a podcast claiming his sister would be vindicated, but again did not say where she was. On Saturday evening, the judge specifically named Jared Kushner as a person of interest regarding the aiding and abetting inquiry. Kushner's attorneys responded Sunday morning, stating he traveled to the Bahamas for scheduled business, committed no crime, and resents the implication. But note what is missing from that statement: any mention of Ivanka, any denial of knowledge regarding her location, or any statement of cooperation. So what is still unclear? We do not know where Ivanka Trump is right now. Marshals say they have credible leads but are not sharing them. We do not know who was on that second plane with the sealed manifest. The tail number leads to a Montana LLC registered just 2 weeks ago with a single attorney in Boca Raton who isn't talking. We do not know if Melania will testify again, though prosecutors have indicated they may call her for the aiding inquiry. Her attorney says she will comply if subpoenaed. The dates to watch are immediate. Tuesday, February 10th, Judge Hayes holds a status hearing. If marshals don't have Ivanka by then, aiding charges could be formalized. Thursday, February 12th, the Secret Service director testifies before a House Oversight Committee, where Ivanka's former protection status will be a key topic. Friday, February 13th, is the deadline for Kushner to respond to a potential subpoena. The clock is running. Every hour she is not in custody, the legal consequences compound. Every statement the family makes is added to the record. Every flight and transaction is discoverable. The machinery of the legal system is moving, documented step by step. We are watching a family that has spent decades believing consequences were, for other people learn in real time that this might no longer be true. I will be watching 3 things closely. First, the Tuesday hearing. This is when the situation either escalates further or begins to settle. Second, Jared Kushner, if he is subpoenaed, the spousal privilege question becomes incredibly complicated regarding what he knew and when. Third, Melania, her silence is strategic, and the question remains, what is the strategy? This story is nowhere near over. It is developing rapidly. The documents are clear, the timeline is established, and whatever happens next will be on the permanent record. We will be here to break down the next filings page by page, quote by quote, because in a situation this chaotic, documents are the only thing you can trust. Stay tuned.